Advocate Zelda Swanepoel says the credibility of some of the witnesses is key to the outcomes of the case. Swanepoel made these remarks as the Western Cape High Court, sitting in Saldanha Bay, is set to conclude its trial within a trial. The exercise is looking into the admissibility of confession statements made by two of the accused in terms of the 2024 disappearance of the little girl.
Now, my lord, it's this simple. If what you're saying is the truth, there would be absolutely no reason why the evidence would change. And that's the state's strongest argument, that the credibility of these witnesses certainly were of a poor quality, and I'm being very kind when I say poor. With the exception of one, the defense witness that was called, my lord, the state will argue, was an honest witness. And I say so for the following reasons. Her evidence was that accused number one had walked past her. It was a few seconds. In that time, the probabilities of her making an observation, state will argue, is very minimal. But she was honest enough to concede that as soon as Mr. Apollo stepped out of her sight, she can't say what would have happened to him. And I even put to her the suggestion that Mr. Apollo could have fallen, Mr. Apollo could have been smacked by Mrs. Smith. She can't say. So I will argue that that witness's integrity is intact and her evidence may be accepted.
Let's stay with that address to the court. Swanepoel has also emphasized that the accused were informed of their rights.
State has discharged the onus. It cannot be argued that these statements were not freely and voluntarily made. I mean, the explanation, see, now you've invited me, so I will talk some more. My lord, the accused legal rights, and I'm referring to accused number two specifically, 5 times was what I counted when he was informed of his rights in terms of that notice, 14A. Accused number one, at least 3 times. So it cannot be said that any of these accused were not aware or properly informed of their rights.
Well, let's continue to unpack this issue of torture claims in the Jocelyn Smith trial. Professor Lukas Muntingh is the director at the Dullah Omar Institute. Prof, it's great to talk to you. Thanks for coming on. What is our record, especially in the police, I suppose, insofar as torture for confession is concerned?
The torture allegations are typically reported to and recorded by the Independent Police Investigative Directorate, and they would then investigate, make findings, and make recommendations to the National Prosecuting Authority to prosecute or not. We don't have the detail readily available to say exactly with what purposes in mind was the torture committed. So it is typically associated in a police context with the extraction of information. But of course, torture can be committed for a variety of purposes, such as discrimination or punishment. And it's not a closed list. So we don't have exact data, but we know that every year, several hundred, if not 1,000 cases are reported to IPID.
Sure, that's incredibly worrying, isn't it? Would you say that it's fair to say torture is quite pervasive as a form of interrogation in South Africa?
We know that from the IPID data that there are large numbers of these cases reported. If we take a closer look at these cases, it seems to be the larger metropolitan stations from which these cases originate. So I think it is a fair assessment to say that it is fairly common that torture and allegations of torture emerge, and that is very worrying from a constitutional rights perspective, because there can never be any excuse for the use of torture, be that by the police or prison officials or any other state official. And because that prohibition under international law and domestic law is absolute. You can never justify torture to say, yes, it's a serious crime, or it is an important case, or the witness is obstructing justice. There can never, ever be any excuse. And that is why the use of torture by law enforcement agencies are so extremely damaging to trust, public trust in the police and the criminal justice system in general.
Yeah. The torture allegations are still being tested in the Western Cape High Court sitting in Saldanha Bay, insofar as the Jocelyn Smith case is concerned, but the claims are shocking. Both of these accused claim that while they were handcuffed and hanging in midair, a plastic bag was placed over their heads. They were hit on the head, legs, feet, and hands. They said they couldn't breathe. They were told that they should shake their heads if they want to speak. I mean, if this is the way that we interrogate, as you say, any suspect, no matter what crime they're accused of, that's incredibly concerning.
If these allegations are true, and one would leave it to the court to make that decision, it is extremely damaging to the process of justice, because we know from previous cases where information that was obtained through the use of torture, in a case in KwaZulu-Natal, the accused were acquitted because this information obtained through torture was used in the investigation and prosecution, and the accused was acquitted on appeal, because the presiding officer in that particular case said that this evidence was the fruit of a poison tree, and the court cannot accept that. It must reject it. So, and that is why the use of torture is damaging to the process of justice and also public trust in the judicial system.
Yeah, I mean, the person may well be guilty, no matter what the case might be, or they might be innocent. The point is that surely someone, or most among us, are going to crack under this level of violence and torture.
There's extensive evidence about the use of torture in the post 9/11 context, and multiple torture victims have stated afterwards that they were willing to say anything and admit to anything just to make the pain stop. And it's perhaps important here just to point out that torture is not restricted to physical pain. It can also be mental and emotional pain. But the requirement is that it must result in severe pain and suffering, whether that is mental or physical. And then, as you quite rightly point out, that most of us would probably cave in under such pressure.